Appeals of Tennessee is now in session.
Thank you, Mr. Hibner. And on behalf of Judge Bennett and Judge McBrayer, we want to thank you, Mr. Peters and Mr. O'Neill, for participating in this oral argument via Zoom and YouTube so that we can live stream it to the public. We will conduct the argument in the same manner as if we were all in the courtroom together. And unless there are any announcements, I'll ask Mr. Hibner to call the case.
Kevin Arnold et al. Versus Beatrice Fowler.
Mr. Peters, you have the floor.
Represent Kevin Arnold. He's a surviving spouse of Linda Arnold. And this is a case that involves one issue only. That's whether the proof presented in this case constituted a delivery of a deed. There's a deed in question. Beatrice Fowler, by the way, in the country, Beatrice is called Beatrice, by the way. So Miss Fowler had 3 children. She had Eddie and Carolyn and Linda. And she decided to give each one of them, and reserving a life estate, of 42 acres each. And so there were 3 deeds prepared, giving each one of those children a 42-acre tract, reserving in herself a life estate. At the same time, there were 3 other deeds prepared, which were quitclaim deeds, which quitclaimed the very same property back from Carolyn and from Linda and from Eddie back to their mother, Beatrice. The first 3 deeds were recorded in the courthouse back in June of 2014. The other 3 deeds were then deposited in a safe deposit box, which was opened up by Linda, and it also had the name of Carolyn on it. According to the proof that was presented, these deeds were taken to Regions Bank, where there was a safe deposit box, and they were placed in the safety deposit box back in June of 2014. The deeds remained there in that lockbox, undisturbed, until in April of 2017, Linda was killed in a unfortunate automobile accident. And sometime shortly thereafter, Carolyn, her sister, who had access to the lockbox, picked up the deed that was in the lockbox, which was from Linda, a quitclaim to her mother, Beatrice, and carried it over to Beatrice, and then it was recorded. The proof doesn't show who actually recorded it, but it was then recorded, and that is the deed that's in question. And the whole issue is, was there a delivery of this deed in accordance with Tennessee law? And Tennessee law says pretty succinctly that before a deed can be valid, it has to be delivered with the intent of the grantor that it be deemed a conveyance. And in this case, we presented certain facts that were ultimately presented in a way of admissions that Linda, during her lifetime, did not authorize or permit the taking of that deed from the lockbox. The chancellor, however, in this case, decided that delivery was necessary for the validity of the deed, but the chancellor stated that this delivery took place back in June of 2014, when these 3 deeds were prepared and were taken to the location of the safety deposit box. Because of evidentiary rulings, there was no evidence given as to what was the purpose of these quitclaim deeds, nor was there any ever indication of any intention on the part of Linda to allow that quitclaim deed to be taken from her lockbox without her consent. The only evidence of intention seems to be in the admission that there was no permission or authority ever given to remove that particular deed. Now, I agree that delivery is not necessary if the intent of the grantor is to make that a valid conveyance. In this case, there was no delivery that is necessitated. There's no proof. There's no state, and there's nothing in the record that would indicate that anybody other than Linda had a right to remove that deed from that lockbox after the expiration, after this much passage of time. Now, of course, there's, and the Tennessee cases seem to be wholeheartedly in support of the position that I've suggested. There is not a contrary ruling. In fact, there's one case where there even was a written designation that it was the intention of the grantor to have that deed delivered. And even in that case, it was not deemed sufficient delivery. I don't know of a Tennessee case that supports the position of Mr. O'Neill, even though he rather eloquently asserted it. And in fact, was eloquent enough to convince the chancellor that he was correct. I state that in this case, based on the facts that were set forth in the admissions, based on the proof that was adduced at trial, and based on the lack of any testimony or evidence whatsoever of any intent on the part of Linda Fowler at any time, that the taking of the deed from that lockbox without her direction, permission, or authority, and then subsequently recording that deed rendered that deed invalid.
Mr. Peters, isn't there evidence that this lockbox was maintained for the benefit of Beatrice Fowler?
No, this lockbox was not maintained for the benefit of Beatrice Fowler. Beatrice Fowler had her own lockbox. There is no such evidence in the record that that lockbox was for her benefit. It was for the benefit of Linda Fowler and Carolyn Mason. There is no such evidence in the record that that was the purpose of that lockbox. If those deeds were intended to be delivered to Miss Fowler, why in the world didn't they put them in Miss Fowler's lockbox? If the court gleans from the record that there was such proof, it escapes me.
I think the answer filed by Beatrice Fowler suggested that that lockbox was acquired for her sole benefit. So what you're saying is that may be in the answer, but there's no evidence.
Of course not. No, Your Honor. I mean, I put a lot of stuff in my answer, and I'm glad they did that. There was a statement in the record by Carolyn, who testified, that's the other daughter. She took it out of the lockbox, and she said that was supposed to be mother's, and that was in that lockbox for mother. But there was never any such indication.
Mr. Peters, doesn't the testimony by Miss Carol Mason constitute evidence?
Well, I mean, Carolyn Mason's statement to that effect is based on nothing but her assertion that that was in her opinion, to be sure, in her opinion, that was mother's deed and that was for mother. But that's not what the evidence shows. The evidence shows that the lockbox was set up near where the lockbox of the mother was. And the only things that were put in those lockbox were those 3 deeds. There was never any property of
So the
Beatrice.
lockboxes are not like horseshoes. Being close doesn't count.
Beg your pardon? Oh, yes.
Since the lockboxes were close, it doesn't count in horseshoes like it does in horseshoes.
No, the fact they were separate lockboxes, being close made no difference. If if it was intended to make this the property of Beatrice Fowler, they would have put it in her lockbox. Why in the world, when they went in there with those deeds, did they then open a separate lockbox? The proof is conclusive. In fact, Mr. Fowler, he was done and billed for that lockbox, and he paid the freight, even though Carolyn said she reimbursed him with cash. It's pretty clear that that wasn't the purpose of it, and there never was any such indication.
Aside from the lockbox, the trial judge in his statement in court said that based on the testimony that's not been refuted, the deeds after they were executed, talking about these deeds back to the mother, those deeds were then given to Mrs. Fowler, which under the current state of Tennessee law would constitute delivery. So if they were delivered to her, does it matter where they ended up?
Well, I mean, there was never any indication that when those quitclaim deeds were prepared, they were ever delivered to her. She said they were.
Somebody testified that they were. Somebody testified that those deeds were given to Mrs. Fowler, right?
Well, hold on. They all went together with those deeds. Ms. Fowler may have had the deeds in her hand, but that doesn't constitute delivery because they were only with her for a short period of time before they were then placed in the lockbox.
You don't have to keep them in her pocket the rest of her life. I mean, she's got to put them somewhere. Why not? Why not? One of the girls says, "Hey, I'll put them in the old lockbox. Mom, don't worry about it."
Everybody knows in the country you put your important documents in a locked up box.
But it would have been lovely for Mr. O'Neill to have been able to present proof that that was the intention. The simple fact is the only contrary intention was that the grantor in this case that is at issue is Linda. And she states in that admission that she did not authorize or direct or permit the removal of that from the lockbox. If it was truly stated that there was a contrary intent on the part of of Linda, they could have refuted that admission by qualifying it by saying that she had expressed an intent.
Mr. Peter, are you asking us to impose a rule of a certain number of minutes or hours of days that a deed must be held by the grantee before it can be considered delivered?
It doesn't matter how long as the intent is present.
Well, if it's handed to Mrs. Beatrice Fowler, do we need to go beyond that to realize the intent was fulfilled?
No, the intent has to be the intent of the grantor, namely Linda. Her intent was expressed contrarily in the admission that was presented. There is no evidence that Linda Fowler ever intended for that deed to be delivered and carried to.
There's no evidence to the contrary. Linda Fowler didn't testify on that point.
There's an admission that is in the record that states that she never and did not authorize or direct that it be removed. If there were intent,
that's a subsequent act. You want us to disregard the earlier event where it was hand delivered to Beatrice Fowler.
well,
And Beatrice Fowler held all three deeds for a period of time, whether it's 5 seconds or 5 minutes or 5 days.
all those deeds were prepared together and said she was in possession, and they all three took them down. It makes no difference whether she had them or not, because you have to have them with intent, and the intent has to be on the part of the grantor.
All right. Thank you, Mr. Peters. Mr. O'Neill.
Thank you, Your Honor. May it please the court. I'm Greg O'Neill, and I represent Carolyn Mason and Eddie Fowler, who are the remaining two heirs of Beatrice Fowler. First, I guess let me skip around a little bit. Mr. Peters' assertion that this admission holds true and is winning his case. Carolyn Mason, the reason that there was not any objection to the request for admissions, Carolyn Mason stated at trial that the position of Ms. Fowler, and that was Mr. Peters takes the position that this deed, the reciprocal deed, the one at issue, belonged to Linda Fowler. Belonged to Linda Arnold. The proof shows, and it's clear, that this unusual arrangement that this family had when the closing took place, the deed back to from Linda Fowler, Linda Arnold back to Beatrice Fowler, when that took place, the deed belonged to Beatrice Fowler. All of these people appeared at one time at I'll call it a closing at a place called a Sovereign Title here in Winchester, Tennessee. This had been arranged, this arrangement that I've never seen before. I've been practiced a long time, and I've done a lot of estate planning type things, and frankly, I've never seen an arrangement set up like this one was, where reciprocal deeds were done and then given back to the grantor. But they were all there together. Ms. Fowler executed these deeds to her children, to Linda and Carolyn and Eddie. At the very same time, right after these were done, she required the children to execute these deeds, these quitclaim deeds, back to her. The purpose of that was
is there testimony that the three deeds were executed by each of the three children signed one of the deeds, and were the three deeds handed to Beatrice Fowler, and did Beatrice Fowler hold them in her hand?
That is the testimony of Carolyn Mason, Your Honor. Yes,
that's what I thought.
It was further the testimony of Ms. Mason that all three of the children did that, as you just stated. When they left the closing that date on June 16th of 2014, each of the three children took their respective deeds, had them recorded. I think the girls recorded theirs the same day. Eddie Fowler recorded his deed 7 to 10 days after, sometime after. And when they left the closing, the testimony of Ms. Mason was that Beatrice Fowler had the three, I'll refer to them as reciprocal deeds, back to her. Sometime later,
Did Carolyn Mason also testify that the lockbox that Linda Arnold and Carolyn Mason maintained was for the benefit of Beatrice Fowler?
She did, Your Honor, yes. And the reason for that was the Regions Bank, they had a larger lockbox that was Miss Fowler's as well, that was in all three of their names. It was in Beatrice Fowler and the two girls, Linda and Carolyn, as joint tenants with right of survivorship. Her testimony was the reason that was set up was Miss Fowler's first lockbox was just jammed full. She had deeds and various other family paperwork in there. And this lockbox in
Suppose if
question,
you did a bunch of reciprocal deeds, your lockbox would fill up pretty quickly.
well, and she had several of those. um, as a matter of fact, we introduced, Your Honor, some subsequent transactions that were carried out between Ms. Fowler and the girls, and she required the grantees to record reciprocal deeds back to her again. There was a transaction that took place, I think in September, the proof showed, in 2014, where she conveyed some rental houses to the two daughters, and at the same time required the girls to execute these quitclaim deeds back to her as well on that transaction. The purpose of that to be that the court could ascertain what the intent of Miss Fowler was. The whole intention was for her to keep control of her property during her lifetime. Like I said, that's an unusual way to do it, rather than just keep the property and execute a will or something of that nature. But be it as it may, that's what they agreed to do. That's what all of the family agreed to do when this transaction took place. And in order,
And the court here only heard from the daughter and the son-in-law, and that was the only two witnesses, right?
that's correct, Your Honor. And the whole purpose of this transaction and it being carried out the way that it was so that Ms. Fowler could control the property. In order to carry that out, everybody had to agree. Everybody had to agree that a valid delivery of these quitclaim deeds back had to take place. And Linda Arnold was there, the deed in question that we're here talking about today. Ms. Arnold was there with her brother and sister, made this conveyance back to her mom like everyone had planned and agreed. And they took those deeds, up to the lockbox that day. There was no testimony as to exactly when it was, but I think, well, I take that back. There was the card, the signature card from the bank showing the day that they signed in to actually put the deeds there. But it was later, after the closing took place, that it was there. And so all of the requisites are met for not only a delivery, a valid and complete delivery, but the intention of the parties. And again, sound like a broken record, but the whole intention of this unusual arrangement was for Miss Fowler to maintain control of the property.
Who
So-
signed the signature cards on the day these deeds were put in the lockbox?
Your Honor, I believe probably, I want to say it was either Carolyn Mason and or Ms. Arnold. That's whose name the lockbox was in. So it would have to have been one or two or both of those.
And Mrs. Fowler, Beatrice Fowler's name was not on this lockbox.
It was not on that lockbox, no, sir.
Okay.
If it had been me doing it, I would have put it the same as the first lockbox that this was directly adjacent to. I think it was number 8 and number 9, but they were side by side with each other.
Mr. Peters has eloquently and repeatedly stated that Carolyn Mason had no authority to remove this deed from the lockbox, that was in the name of both Linda Arnold and Carolyn Mason. What do you say about that?
Well, the lockbox was in their name as in their names, as joint tenants with right of survivorship. After Mrs. Arnold's passing, that lockbox belonged entirely to Carolyn Mason. She's the one that had control over what was in it.
So I gather from that you respectfully disagree with Mr. Peters.
Absolutely, Your Honor. And Mrs. Mason stated multiple times in her testimony that she, not only she, but she and her brother considered those reciprocal deeds to be the property of their mother. And they confirmed that arrangement to be so that Ms. Fowler, again, if she changed her mind about things, could take those out and re-record them in her name. It's obvious that that's exactly what happened. After the unfortunate death of Linda Arnold, her mother, Ms. Fowler, decided she didn't want her grandchildren or her son-in-law to have that 42 acres. She wanted somebody else in the family to have it. That was the whole arrangement to start with. If she changed her mind and wanted to give it to somebody else in the family or some other third party, she would have the authority to do that. And that's exactly what happened. The cases cited by Mr. Peters in his brief, the Proctor case in particular, is clearly different than the facts we have before the court in this situation. The Proctor case, that deed was delivered to a third party as an agent for the grantor, with instructions to deliver the deed to somebody later on down the line after the grantor's death, particularly. In this case, again, everybody was there at the closing that day on June the 16th at the title company. Everybody agreed that at the conclusion of the closing, Mrs. Fowler took possession of those 3 reciprocal deeds back to her, including the one at issue, the one from Linda Arnold to Ms. Fowler. And as Your Honor stated, when that delivery was made, she can deposit them or do with them as she pleases. And that's what happened in this instance. And with all due respect to Mr. Peters, his massaging of the facts don't entirely jive with the proof that's in the record, because there is proof that that Ms. Mason testified the reason for the lockbox. Those admissions mean essentially don't have any bearing, because it was property owned by Ms. Fowler, the deed in question, after the closing took place. And Carolyn Mason, first off, didn't need any permission from Ms. Arnold or her family to do that, because the deed in fact belonged to Beatrice Fowler. And we believe, if Your Honor please, that all of the requisites factors are there for a valid and complete delivery, including the intention of not just the parties to the transaction, Linda Arnold, Ms. Fowler, but everybody else in that family situation that took place that day. I'll be happy to, I'm about finished with my time, but I'll be glad. Any other questions?
Colleagues, any questions? Hearing none, thank you, Mr. O'Neill, and thank you, Mr. Peters, for your arguments. We will take this matter under advisement. Mr.
Thank you,
Hibbner.
Your Honor.
Mr. Arnold.